Good evening. It's 5:35 on November 9th, 2011. It is the monthly meeting of the Urbana Human Relations Commission. Could I please have a roll call?
Francis Rigberg Baker,
Here.
Carol Bradford, Rita Haber, Daniel Larson,
Here.
Lisa Mosley, Peter Resnick,
Could you?
Peter?
I heard it here, but it was very.
Yeah.
he's
very
waving,
low.
yep. Eric Smith,
Here.
Can't hear.
Aisha Lamsob, and Rizwan Udin.
Here.
Thank you. Looking over the agenda, are there any additions that need to be made or corrections? Hearing none, do we have a move for approval? All those in favor, please say aye. Opposed, the same. Thank you. Looking at our October 12th minutes, are there any additions, corrections, subtractions that need to be made? If not, is there a motion on the floor for approval?
Second.
Thank you.
You meant November 9th minute or
Our approval from our October meeting?
meeting?
Yep. So we have a motion on the floor for approval. All those in favor, please say aye. Opposed, the same. Thank you. Public participation. Mr. Cruz, please, join us up here.
Thank you.
Before you begin,
Think
sir,
this
could
is
I,
on. I assume.
there we go.
Okay.
Peter, are you picking up everything? We cannot hear you. Nothing yet.
All right.
Can we wait just another second, Mr.
Sure.
Cruz?
That'd be fine. It'd be nice if Peter could hear.
Yeah. Should I let the folks know? Yeah. Video's perfect. Just- He does. You look, video's good, just no sound, no sound. We had the sound for a moment. All right, we're going to move on. They're working on it. Pete is, just raise your hand. Get our attention. We'll make sure
that
we,
any better?
we check in. Sorry, Mr. Cruz, please.
Testing, 1, 2,
Well,
3.
that's fine.
Oh, sorry.
Just a couple of, I think, two topics I'd like to quickly address with our commission this evening. And I know the commission is extremely interested in the IDOT traffic data, and it has been working with the Human Relations Office for the city to address that. I just wanted to distribute the first point being the two graphs that I passed around to you. They just refer to the data in 2010. You may be well aware of it. I'm not sure. I think the data that has been shared in the past did not include 2010. But the first graph, which is a line graph, basically shows for the first time since the traffic stop data was collected by the state of Illinois that minority drivers in Urbana were stopped at a higher percentage than Caucasian drivers. And you can see that the trend there has made those two lines cross for the first time, which is rather significant when one considers the population numbers for Urbana to be roughly 69 to 70% Caucasian and 30%, 32% minority drivers. So for the first time in the 7 years that the data has been collected, more minority drivers have been stopped than Caucasian drivers. Now, when you turn over to the back side of that, it breaks out those minority drivers into their disaggregate groups, and basically the IDOT traffic data breaks them into African Americans, Hispanics, and Asian Pacific drivers. And what the graph shows there is simply the percent of the stops that each racial group was composed of during 2010. It's important to note that the African American driving population and Asian Pacific driving population are relatively close in numbers in Urbana, roughly 12 to 13%, give or take a percent or two, and Hispanic drivers compose 3 to 4% of the driving public. But when you look at the percentages, there's only one racial group that is significantly higher than its percent of the driving public, which you're aware of. But what's significant is that about 37.5% of the stops involved African American drivers this past year, while they only composed about 12 to 13% of the driving public. And so they are stopped roughly 3 times their percent of the driving public in Urbana. And so I think this is an issue that the whole community needs to be aware of and address and look at, and I know the city is doing that. Okay? Now I'd like to just make one other quick comment, if I could. I looked at the video streaming on the website of the HRC's meeting in October, and I believe part of the agenda at that time was the HRC is beginning to look at bringing an individual into the city, a nationally recognized expert, to address non-biased policing. And a couple of comments that I have with regards to that I would like to make, and then I'm sure we'll learn more tonight as we're updated. First of all, I do want to commend the city for recognizing that this is a problem and that they in fact are taking steps to address this problem in ways that I think are important. But I would also like to say that I think there's a serious flaw in the process they have chosen, in which they have chosen how to address this. And that is simply that the city continues to address the IDOT traffic racial disparity internally. It's making plans of how to address it with little or no public input or engagement from the individuals and the community organizations most affected and interested in this issue. One of the things I've noticed about Urbana city government is generally when a problem or issue is brought before the city, those individuals or groups or people that are affected or involved in that particular issue are generally actively encouraged, and the city develops means or ways for them to participate. A couple of examples would be when there's the issue of safety in the neighborhood. There was a request to address that, and there were neighborhood safety task force set up where there are citizens involved with the city staff to talk about those issues from a citizen's perspective and a city's perspective and the resources and how we might proceed. I know when there's cities looking at economic issues or development in the city, many times the developers or people that are coming in actually are invited by city staff to come in and talk with them. How can we work through the issues and the zoning and the ordinances and types of things that the city is addressing? Well, when it comes to community police relations, okay, we just look at that, and I don't see that as negative at all. It's just another issue or topic that we're confronted with by the community. The city has chosen not to engage the public in a direct way and in the process of determining how the city might respond and how the community is affected by it. And I will simply say that I know that groups like CUCPJ, the ACLU, the Black Ministerial Alliance, within the last, I would say, 13 months, have asked on several occasions to meet with the city staff and the Urbana Police Department, and never once has that occurred. Never once has that meeting ever happened. There has never been that opportunity for people most interested in organizations most directly involved with us to have a conversation with the city. Instead, the city has decided to handle this particular community issue internally. It's been a conversation that has occurred basically between the Human Resources Office, the Mayor's Office, and the Urbana Police Department, and they have shared their plans, their thoughts and ideas publicly through the HRC meetings, and they have taken steps to begin to address this issue. But all of that planning, all of that discussion, all of those things have been done basically, as many people in the community said, behind closed doors and without a knowledge of how those decisions are made or what's going on. And so I would simply like to ask the city and the HRC and the Human Resources Office and Urbana Police Department to consider looking at, as they continue to move ahead, to open the door and invite people that are concerned about this issue to have direct involvement and participation in the discussion of why does this disparity exist? You know, we don't know why, and I think the community is, why is it occurring? What type of information and data is important to be collected? And I think the input can provide some support and ideas to the city to that. And then once we have that information, what is the best response? Many things I've read, non-biased police training may or may not address this. It's a very complicated issue. I'll withhold judgment until we see what occurs. But I would say that a perspective is sorely lacking, okay, as the city moves ahead on this issue by not involving those people that are most interested and those organizations who have expressed a desire to work with the city on this. And the last comment I would like to make, I understand that this expert is possibly coming the 15th, 16th, and 17th of December, a couple of days, possibly to work with the police department, and then a 4-hour public forum meeting. I would simply say that the city's definition of public engagement so far has been to come and speak before the Citizens Police Review Board, to allow us to come and speak to you. And then there was, in a July meeting, one public hearing, but the time allotted for public input discussion was just a fraction of what that 2.5 or 3 hour meeting consisted of, and was sorely weak in involving the public. So my concern is the meeting or the forum that's scheduled the week before Christmas is not a really great time to plan public input, but the public has no idea of what the format's like or what the design or what the purpose of that would be. And I think it would be advisable if the city would ask the public or some of these groups, what would we like to accomplish? What are we trying to do through this forum, rather than it being, I don't want to say manipulated or controlled or designed within the city. The public doesn't have a voice in the public forums that they've even set up, at least to this point, and I see that as an extremely big weakness. And so I noticed that there was a possibility that there might be an opportunity for this expert who wanted to maybe get some context before he came to the community, to have some pre-conversations, I assume via teleconference or phone calls, or maybe coming early before he comes to Urbana. My suggestion would be strongly that the Human Relations Office contact the ACLU, CUCPJ, the Black Ministerial Alliance, or other individuals they know are interested, and ask for names of people, if they want to do this, that are willing to come forward and assist the city in addressing this issue in a constructive way. I don't know that any of these groups or individuals have been contacted at this point about that opportunity, and I would hope that the city doesn't selectively pick individuals based upon some personal or political preference, rather than individuals that are interested and concerned about this issue. If that pre-conference or that pre-meeting might occur, that people are there. So I would like to simply say I commend the city and the staff for the work that they're doing, but I would like to express some concerns or reservations about the nature and how they're doing it and the lack of direct community involvement and engagement in an ongoing way with the city to discuss this topic, because it is an important topic, and I would encourage that somehow that be improved. Thank you. Yes.
Thank you. Fran?
In your opinion, when we had the other meeting, which was frustrating in some ways for you, in your opinion, was that meeting in some ways, as it should have been, were the right people there, in your opinion? And if not, was that because they were not in, well, were they or were they not the people you would have liked to have seen informing the city?
I think the initial intent, as we were informed of that first meeting, is that would be a public, meeting, not a forum or something. It would be something where the public could come and speak to and address the issue and express concerns. And in fact, the format of it was about the first 2 hours of it was staff presentations, and it was commission comments and questions. And the public, as a result of the length of it, basically it got squished into about 20 minutes, but then there were some issues, and I remember feeling very frustrated because we were led to believe there'd be an opportunity for more public input, more public engagement, and actually we were cut off. And it wasn't the kind of the meeting that I think the public was looking for. And I think that was because the public did not have an opportunity to dialogue with the city beforehand in terms of what it might like to see happen.
Right. I know I know that you have some criticism about the design of that meeting and how that meeting played out and its organization and how time was allotted and so on, but that's not my question.
Okay. Sorry.
My question is, in your opinion, were the right people representing the public that you see should be informing the city in this issue, were those people present?
There were a number of them, yes.
Okay. I just always wondered about that.
Yeah.
So in terms of their access to that meeting, in terms of attendance, not maybe in terms of their ability to speak and inform, but in terms of their presence, that part of it was satisfactory from your point of view?
I think it was satisfactory.
Okay. Do you remember the only other issue of this nature that I'm familiar with is the one I was deeply personally involved with, and that was when anti-Semitic broadcasts were coming out on the public airways, on the on our public access TV. I don't know how aware you were of how that played out, but there was a lot of involvement by the public in engaging in all kinds of ways with the commissions and councils and officers that govern the city. And people on all sides of that spoke, and it was very polarizing and very passionate. I don't know how aware of that, but if you were aware of it, did that seem to you to have worked in terms of the public, concerned public, being able to affect the response of the city?
Okay. I see that issue and this issue as being somewhat different. Yeah.
They may be different,
Yeah.
but they're passionate issues involving civil rights, involving racism, involving prejudice, and so forth. So I think they do have some in common, but even aside from that, there was an issue of public concern and municipal response, and that's what I meant.
And here's what I was going to explain in terms of the difference, because I agree with all that you've said so far. The difference is in terms of this particular issue involving police-community relationships, or the IDOT traffic data, versus the free speech rights and the anti-Semitic programming and stuff that was going on our local public access TV station, and I was on the commission at that time. Okay, so I'm fully aware of the whole experience that the city went through and had conversations with a number of people at that time, is that I think that was an issue that in its singularity could be identified in discussion, addressed in some resolution, probably arrived at in some sort of reasonable amount of time, where this is a much more difficult, long-term type of question or problem to address that's going to, in my mind and from people I've talked to, take an effort to really dig a little deeper at root causes and gathering information over an extensive period of time, like maybe for a year or more, to see what's going on, asking the right questions. What do we need to know? How do we get it? How are we going to respond? What are the right actions? It's not that there aren't some similarities, but in terms of engaging the community and how we approach the resolution of the problem and make sure that the actions that we're taking are things that are going to rightfully address it in a positive way that makes us a better community, I think this issue is going to take time and take an effort to do that. And the other point, and maybe this is not a fair one, is that there's a unique relationship, whether one necessarily sees it in a broader community, between the minority community and the police department in terms of how that has existed historically over time and where we are now with it and how they respond to those issues that complicate it a little bit. And so we need to be aware of those things and look at, especially at how organizations and particular individuals that are most interested can have that dialogue with the city.
Any other questions? Well, thank you again
Okay,
for
thank you.
the graph. And Peter, did you get a chance to see this graph?
I did not. Can you folks hear me now?
We can.
Okay, good. No, I'll take a look at it. If Daryl can forward me by email, that would be terrific.
I can do that.
Great. Thank you.
Thanks.
Alrighty, moving on to our next item on the agenda. We have some old business to discuss. Todd, where would you like us to start?
So I think we can start at the very beginning.
Great.
Disclosure of information subsequent to probable cause findings. I think that's a discussion that we sort of put on hold, and I've invited Michelle Brooks here because I know that there were some questions for her as our assistant city attorney who works with the HRO. So I'd ask her to come on up and let's go ahead and discuss. I think, Peter, you had raised some questions about this, so maybe the natural starting point would be for you to sort of begin to present those questions.
First, thank
Well-
you for coming to our meeting.
Absolutely.
Peter, take over.
I'll try not to take over.
Not take over, but get us started.
So let me start with the primary question for you, Michelle, which is, in your discussion that you sent by email through Todd, you had mentioned that there was no requirement, as far as you could tell from the ordinance, that we reveal the names of the parties. I guess and that the reason you said that was because there was no specific language in the ordinance, so it was an issue of interpretation. The two questions I've got are, is there anything in the ordinance preventing us from revealing that information? And, well, let me start with that. Is there anything preventing us from revealing the information?
Is there something that specifically states in the ordinance that under no circumstances shall names of parties be released in discussions regarding conciliation agreements? No, there's not. What there is, and again, ultimately this is a policy decision, in my opinion, for the commission to make, but what there would be then is some inherent tension in what purports to be the mission of the ordinance, with the possible consequences and effects of releasing certain kinds of information regarding conciliation agreements. So in terms of what specifically can and can't be said, I don't find that dictated specifically or prohibited specifically anywhere in the ordinance. It really then just that's where it kind of evolved out into a balancing test and trying to look at tensions or inferences.
So now let's talk about that. The two things that I see weighing in favor of revealing the names of the parties is, first of all, that the ordinance does anticipate that an order of a conciliation agreement after a probable cause finding would be revealed. As a matter of fact, the conciliation agreement itself is one of the exceptions to the confidentiality clause, the terms of the conciliation agreement. The other is what I would think of as an overall tenor of the ordinance, that there are certain things like a public hearing which are in the public interest, that there's a level at which you do want to reveal information about these things, so it's part of a public conversation. The thing I see weighing against that is, and I've obviously had discussions with Todd about this and a little with Eric Smith about this, is that there are some tools in the bag right now about how to get parties to come to some sort of resolution without going to public hearing. Right now, it's in part the threat of the public hearing coming up and the determination of probable cause, but what Todd was talking about was having another tool, which is the threat of going public, is a useful piece of information to, use for leverage. I wonder if you could talk about whether you think the things weighing in favor of releasing that information I've gotten right.
I think you actually have hit exactly the notes that I had here that I was going to raise if asked that specific question, and I think you actually articulated them better than I would have. That is, to me, exactly the pros and cons on both sides of it, and the tension inherent kind of in situations just like this. We are looking to end discrimination within the city of Urbana, and so there is obviously a public interest in that is very great, and information being put out about findings that may have been made regarding that is obviously one of public interest. However, we're also primarily, well, I don't want to say primarily, that's for you to decide, but we're looking, and the first statement in Section 1283 implies that, or states, we're looking to compensate the complainant and eliminate the discriminatory practice. So then we have the needs of the individual that kind of are put very clearly up front as a primary concern and consideration. So when I look at anything that might have a chilling effect on trying to get some resolution or restitution for somebody who may have suffered a harm, that's exactly, I think, what maybe you were speaking to, and that where I was kind of going with my memo and what I was going to say here tonight. There are, in my experience, there are several different reasons why somebody who would be a respondent in this situation would be willing to enter into a conciliation agreement. One is because they worry that there would be a finding against them made by the commission. The other is just that they don't want their name out there because they understand that public perception, even if the commission finds, that no discrimination took place, they just don't want their name attached to that kind of allegation in the first place. And another is that it's, there is an investment of money and, for legal assistance for them to come in and defend that kind of action. So those are reasons why, a respondent would want to enter into a conciliation agreement. Now, in addition to getting compensation, the complainant, has incentive to enter into a conciliation agreement, because a lot of times what would happen is a respondent would come in and try to justify, in the case of a wrongful, somebody trying to allege employment discrimination, the respondent will come in and try to justify their reasons for terminating the complainant and may say disparaging things or make allegations about, deficiencies regarding that complainant, inappropriate conduct. So that brings a level of embarrassment and being put into the spotlight for the complainant as well. So anytime we have to tell people that something that they have done to stay out of a public forum may be released into a public forum in any capacity, it could have a really, in my opinion, a chilling effect. Plea agreements, settlement negotiations are not admissible in courts of law. For various reasons. They don't ever want a jury to think that because somebody's willing to enter into those could be considered admissions of guilt, but they also realize that there are a lot of factors that go into why parties reach settlement negotiations, and that those two parties are the best people to determine what's in ultimately their best interest. So they don't want to have a chilling effect on people's incentive to do that, and that was kind of primarily my concern about trying to be very careful about what information you deem appropriate terms.
So let me ask about that. In the case of a settlement, that would occur before any formal proceedings take place. And we do encourage that. As a matter of fact, Todd, I think, has gone above and beyond the call as far as giving people the opportunity to really try and settle things before they get to any stage where things would be public. We have a whole distance of time during the investigation where that can take place, and as a matter of fact, a little bit after. So I think we're talking about where the line of when things turn from private negotiations to settle a case to public participation in the process. The other question I had, is there anything in the ordinance that would prevent, for instance, the initial determination of probable cause to sort of take place at the instance of it being presented to the commission? So what I'm thinking of is something like Todd can say to the parties, look, I'm about to submit to the commission my determination of probable cause. As soon as that happens, things are public the day of the next HRC meeting. Therefore, if you're going to have a private settlement, you want that to take place now. Is there anything to prevent that kind of, Todd can give them the heads up of specifically, I have written up my probable cause finding, it becomes public when it goes to the commission?
I want to make sure I understand your question. Is the question, can Todd let them know that, look, this is where I'm going, this is what I'm going to say to the HRC, or is it that when the whole situation is first brought to the attention of the HRC determines in stanter whether or not there should be a probable cause finding?
No. Not the latter. So,
okay.
And let me split the former for you for a second. Todd's going to make an initial determination of probable cause. Can he say, without revealing what that decision is, that he is going to be presenting that to the commission on such and so a date? He's made the determination, but he doesn't reveal what it is yet, but that's the date that it's going to occur. So if any further settlements without revealing the names of the parties and the settlement agreement, if any of that is going to occur, it's got to occur before such and so date. Then a second question, can he say, I have made my determination, it is that there is probable cause, let's say, and therefore if there's any settlement, the settlement must take place before the day that I present this publicly to the commission.
Okay, so you are asking whether or not Todd can say to the parties and basically give them a drop-dead date saying, on this date, I'm going to the commission, I'm issuing my report, and by that date or before that date, if you're going to enter into a settlement agreement, it has to happen before that date? I'm sorry.
Right, and then
okay.
anything after, any settlement after that we come up with will involve my office and therefore be public and, will be revealed to the commission. They'll have to issue an order, et cetera, and so forth.
Okay. I do need to say at this point that I would want to, with those questions, specific questions in mind, be able to go back and actually read the ordinance over and speak with Todd about that, and I can write you up a response to that, and I can get that out to the commission as soon as possible. By early next week should be feasible. But that is interesting because that touches on something, just a point that I was going to raise, which is that in determining the terms that the commission deems needs to be released, depending on what they were, if it were going to be that specific, what I would historically call terms of settlement agreements, the amount of money exchanged, the parties between whom it was exchanged, any kind of behavior that was no longer was going to be constrained, or any commitment to take an action or to cease an action, if those things were going to be released, I would think the ethical thing to do would be to let the parties going into it know that, look, if you're going to work on this with our office, you need to understand that at these points in the process, this information will now be released in some form to some forum so that they can make the determination as to whether or not they want to step out of this process and resolve it themselves. So that's just something I think, and I think you were kind of touching on that parties, I believe, have the right to go ahead and try to negotiate them on these issues on their own, and I think that they are informed of that. But I do think that it would be appropriate to go the further step and let them know, once we've made the determination as to what terms that the HRC is advised of, that will happen. Because, as I've indicated, every one of these that I've been involved in any settlement agreement I've seen in other contexts does have that non-disclosure provision in it. And we want the parties to know, look, they can bind each other to this, but if we are involved, we are not technically a party to it, but this information that you believe is going to stay confidential will be released by virtue of the forum that you use to pursue this matter. Does that make sense?
Right.
Okay.
Now that's exactly what I was trying to get my
Okay.
arms around. So yes. I just want to give others a part.
Okay. Good. I'm glad I got there eventually, even though it took
Ask
me a while.
questions.
Sorry.
Does that mean if the parties decide to settle the agreement without the assistance of Todd, that their agreement would remain confidential among the parties?
Now I'm going to let Todd speak to how he works with people on this, but well, first I'll let Todd speak to that, and then I can, augment on that.
Yes. If they negotiated outside of the auspices of our office, we do not necessarily have to have any knowledge of that, and they totally have a right to do that because it's their charge to withdraw or to keep. One other thing I guess want to point out, as you're considering from a policy perspective, how to balance these competing interests of, the public interest in knowing and sort of the enforcement value of that, and the interest in achieving some type of settlement and resolution for both parties. And I will tell you that oftentimes, as you're considering this, you should consider that in 9 out of 10 of our cases, the party that is represented by counsel is the respondent. And so the Human Relations Office role in that is not to be a representative for the complainant, but we certainly find ourselves in the role, as we just did this very week, in negotiating, or at least participating in sort of these settlement types of things, in helping to ensure that no party has an unfair advantage or behaves opportunistically in regards to the other party that is not represented. So at the very minimum, I think our job is to balance and to say, okay, everyone, when you're coming to this agreement, no one's going to take advantage of the other because they're not represented by counsel or because they're in a weakened position. Because if we find that happening in the Human Relations Office, we will not recommend that settlement be inked, or at least that settlement be executed. That is often the case. And so to then have almost in a situation where parties, in order to actually get to settlement that can remain confidential, to to have it so that they have to negotiate that outside of anything that we're involved in may ultimately, and I probably believe will ultimately, disadvantage one party over the other most of the time.
Yes.
That actually
Um,
answered my second question. So, thank you.
I believe
Go
Mr.
ahead.
Resnick has a question.
Pete?
Yeah, so to Todd's point, I actually think that in some sense this is exactly right, but is also the reason that I want to put in some sort of more interesting deadline. As I think I've said before, we're making a policy not just when we've got the good folks in the HRO's office that we do now. We're making a policy that's going forward, maybe deal with the potential for bad people being in the HRO's office. The main concern I've got is that negotiation where the respondent is usually represented by counsel and the complainant is often not, if folks go to the HRO's office with the bad HRO and that person weighs in favor of the respondent and says, you really need to take this $500 and be done with it. And that happens consistently with the same respondent again and again, that bad HRO doesn't ever have to reveal to the commission and to the public. That's exactly the time where bad things will happen. Whereas if we can say that determination of probable cause is the point at which the commission gets involved, and there are timers in the ordinance, and obviously we've been relatively lenient about when those timers kick in, but there are timers where the commission with a bad HRO could go to the HRO and say, you need to make the probable cause finding now, and if you don't do that, or if you find no probable cause when there ought to be, that complainant can come and appeal, and we can start the actual process of making that public. Whereas in the current state of affairs, if we don't have that point in that line in the sand where we say beyond here things go public, we could have a bad HRO ending up doing bad things. So that's kind of where I'm coming from, and we've got to set the policy for the worst times, not the best times.
So,
Fran?
I guess my basic question is somewhat complicated for me, but is, and I don't know if there's room for this argument, but is it worthy, if our office, if officer of the city finds a probable cause that a case is worthy of or sufficient for, requires a public hearing, is that something that the public has an interest in knowing? It's like an indictment. I mean, somehow, rather, a little loosely. And that would be a matter of public knowledge. It should be a matter of public knowledge. And is that just naive view, or is there
no,
an issue there?
I don't think it's a naive view. I think this is more of a policy question than anything else. And you can, if you want to weigh in legally. You know,
That's the question
I think I'll try to deal with both questions here. In terms of whether or not the public has a right to know, absolutely. The question is balancing the public's sort of the enforcement value of the public knowing against the value of potentially not being able to get a resolution that puts a settlement in the hands of the complainant. A complainant who, in most of these instances, even if they could afford to be represented by counsel, I'm often told no lawyer will take these cases, right? And so, again, we're not representing anyone here, but what we are is sort of a fair arbiter, or at least we try to be a fair arbiter of these situations. And one of the things that we discussed last time, at the last meeting, is oftentimes it is the probable cause finding itself and the analysis and the reasoning and the findings that go into that prompt the respondent to go to the negotiating table. And I think maybe that's where you're trying to get at, with sort of trying to tip our hand in some type of way prior to, I guess from my perspective, it's just a timing thing, because if we don't get the negotiated settlement within the 42 days after the probable cause finding, then the names are going to be released necessarily because we're scheduling the matter for public hearing. So it's a question of, in that 42-day time period, is there a substantial loss to the public interest if those names are not revealed, or is there potentially a substantial loss to the complainant? Because really, you're just talking about a matter of timing.
Well, again, I agree. And I think the small bit of additional information that the public would be interested in is that once there has been a negotiated conciliation, not a private settlement, but a negotiated conciliation, and we're splitting a pretty fine hair here, with the Human Relations Office, at that point, it's certainly in the public interest to say, hey, are we getting a lot of $500 negotiations being settled by the HRO's office, and why is that going on? Or a lot of $50 ones, why is that going on? Or a lot of $10,000 ones.
Right.
All of these are of interest, I think, to the public, where obviously if there are lots of private settlements beforehand, maybe not so much. And it's not just that it comes to public hearing that is what I think engages that public interest. And again, it's where to draw that line. And in addition, we've got this one outstanding one where, and I think we have to probably make an exception whatever we decide as far as policy goes, we've got an outstanding one where the parties were not apprised of what could be not confidential anymore. So we have to deal with that, I think. And by the way, that actually should be a question to Michelle.
Actually,
Can we
they were
deal with
apprised in this case.
one case separately?
They were apprised in this case.
Oh, they were apprised that
Yeah. And
before
basically
making
the warning
settlement that
was-
it could be made public.
Yeah, basically the warning was, at the point at which no probable cause or initial determination occurs, we have very little or no control over whether or not this information is made public.
Okay.
So, I mean, that, I'm generally a pretty risk-averse person, so I'm going to give that type of disclaimer. However, again, looking at these cases as someone who's looked at them for the last 4 years and worked them intimately, I have a strong, strong apprehension that there are individuals who would be able to get settlements where, if you're revealing them at the time of probable cause or after probable cause, will not subsequently get those settlements.
Right.
And that, I think, is a fact. And whether or not you have a good person or a bad person in the office is probably, if you have a bad person in the office, they're probably not going to find probable cause to begin with. You're not even going to get to that stage, you know, where that's going to make any difference anyway. So, I mean, I understand the points, and they're excellent points. It's just, looking at these from a matter of experience, I am very concerned that there are people who will need settlement monies and will need these resolutions who will not have that access.
I will just echo what Todd said. I've been able to be involved in some of these, and I do agree with everything that he said, and I would just augment the fact that many of these people, from what I've seen and I've heard too, they have come in and said, look, I've talked to lawyers, no one will take this case. And we make it very clear. And just by way of information, when Todd is working out a conciliation agreement, he lets me know, and Todd and I will sit down and we will go over the agreements separately. Then we meet to talk about them, and they go back and forth between the parties several times. We go over them with his perspective and with my perspective, and we will send it back saying, we object to this language, here's why we object to this language, we want this language inserted. So there really is a negotiation that happens, and we really do our level best to make sure that fairness is done for the complainant in these cases. At that same time, trying to make sure everyone understands, and we work very hard to make the complainant aware that we work for the city. We are not their attorney. They are welcome to consult with an attorney at any time. We make sure that the agreements give them time to do that, to walk away from the office with a copy of that, to meet with an attorney, to talk with an attorney about that. There are times we work with the attorneys for the the complainants, and there's group discussions about that. So, I agree that that we work very, very hard to try and help people that often wouldn't be in on a level playing field, but for the City of Urbana, the Human Relations Commission, and the Human Relations Office. But there are people that I believe, just in my experience, that wouldn't come to the table to negotiate if they thought by virtue of them coming to the table that any information would be released, and they would, I think that they would just draw a line in the sand, and I think ultimately it would be the complainant that suffers in a lot of situations like that.
Any other questions or comments? Pete?
So, I had a motion on the floor. What it sounds like to me, my basic question now is I want to thread this needle. I want to figure out a policy where, in enough of the cases, there will be the kinds of settlements that we think are good outcomes. And that when some line is crossed, and I think it should be before public hearing because of the concerns that I've got about when these things take place in worse situations. I think there should be a line before that public hearing. What I'd like the policy to be, if this is a reasonable compromise, is that Todd could tip his hand as to the outcome of that probable cause finding before it becomes public information, before it goes to the commission. And that as soon as the probable cause finding goes to the commission, everything after that, any conciliation that is reached through the HRO's office, is public information. That gives both parties the opportunity to know what's coming and to decide whether they're going to negotiate that settlement. And at that point, if parties are not willing to negotiate, obviously it can go to a public hearing, but there is that point in between where, look, the terms of this are going to be public, and the commission is going to take responsibility for making sure that the terms are met, which doesn't happen officially in public before the time of probable cause finding. I guess I'd like to get a sense of the commission as to whether they think something along those lines is workable as a policy, will satisfy the concerns and balance the concerns, yet still have a decent outcome.
Fran, please.
I'm not sure what we would be gaining from that. Especially don't like the idea of they know about it, but it's not official. I think the way it is kind of serves that purpose.
So,
and,
Fran,
and it's cleaner.
I would argue that the way it is violates the ordinance, because we have not revealed to this date, as far as I know, post-probable cause conciliations, the terms at all. So, we've got to reveal something, at least the terms, and issue that order.
Todd has a point here, Peter.
Yeah, so at the original meeting where we actually discussed this, we actually disclosed the terms of the conciliation. We did not disclose the names of the parties. So we said the amount of the settlement, we talked about the conditions of the settlement, the confidentiality, and the other conditions of this under which the settlement occurred. So in terms of strictly, and that was why we had legal actually look at the language to say, is there a requirement to reveal the names, or is there, when you're talking about revealing the terms of a settlement or a conciliation agreement, do those major terms, would they suffice? And I think the answer was yes, those terms, absent the names of the parties, suffice.
I know
So,
that. I'm sorry.
Michelle, maybe I'm incorrect. Did I not hear you say before that the names of the parties are generally considered part of the terms of an agreement?
I don't know that I said specifically names of parties are terms, and if I did, I didn't mean to. I guess I think that one of the concerns I have is that maybe I am speaking of I don't know that I have a clear, defined definition of terms, and I thought that that's kind of what we were all here trying to decide, is what exactly the terms would be. And in my memo, which I know you may not have in front of you, I had outlined 7 things that I thought would be appropriate terms that I had hoped would address the intent of the ordinance and the desire for the commission and the need for the public to have information, while not giving any disincentive to the parties to still continue to negotiate after a probable cause finding. And they were the case number that had been assigned to the complaint, the date that the case was open, the date the finding of probable cause was issued, that a conciliation agreement had been reached, the amount of any financial settlement, the date of the execution of the conciliation agreement, and any steps that would be taken to monitor the agreement. So it didn't say the names of the parties, but just that it would have been identified by the case number previously given to you.
Any behaviors, you didn't mention behaviors of the respondent that would be restricted or anything like that. Would those necessarily be included?
I think that that's a sticky wicket, because if you get too specific in those, that could give information or inference as to some of the involved parties. So if it were something that you wanted included, I would suggest that it be done in very general terms, and I would kind of defer to, again, that's a policy question, so I kind of defer to Mr. Rent on that. But that is just the one thing I could think of, that if you got too specific in that kind of language, a party could be concerned that would let one maybe guess or speculate as to who the respondent was.
Yeah, again, I mean, if we are supposed to issue an order in order to monitor whether the terms of the agreement have been met, that means that, and the commission has a responsibility in the ordinance, or we can give it to the officer, but the commission has the responsibility to investigate whether the terms of the condition have been met. That means that we as the commission are going to be given the specifics of those terms so that we can figure out whether the conditions have been met. I don't know how we can properly do that and not reveal at least the specifics of what each party is required to do, be it payment or other behaviors.
I fully agree. I agree with that. I think that has to be part of the terms. And when those types of, it would be somewhat similar to a consent decree. When those are part of a conciliation agreement, those would be revealed.
And if those happen to give some information that might reveal the parties involved,
then fine.
We live with that.
Yep.
Other questions, comments for Ms. Brooks or Fran?
It does seem to me, since in hearing all what you've said, that this period, there's sort of this unique period when they know there's been a determination against them, but they still have an opportunity to protect their identity. And if we don't have something like that, sort of an informal thing of tipping the hand, which kind of makes me uncomfortable, you need something like that. It seems that you're giving up a piece of important leverage. That's all I would want to say.
Peter, anything else?
No, I guess it's just, I mean, I don't particularly remember the exact motion I made. I certainly think we need to issue an order, just pro forma at this point, because I believe not only has the agreement been made, but I think all of the terms have been satisfied. So we're strictly doing it pro forma at this point. I think we do need to issue the order. The question is what goes in the order. I don't know that I, in my motion, made a particular... does somebody have the text of my motion?
It's in the minutes.
I don't have that.
Okay.
Mr. Resnick made a motion that the commission issue a formal order with terms of conciliation when a human rights case is settled. The motion was seconded at that time by Mr. Larson. Thank you, Tony.
Okay, so we haven't spoken about the specifics of what goes in that particular order. I think the motion on the floor is that we issue an order. I think after if we agree to issue the order, then the question of do we reveal the names or not is the next order of business, and maybe we need to decide that during the discussion of that motion, which is on the floor.
So, Peter, how do we,
Do you want to take a vote on the motion just as it stands and not determine the text of that order
Oh, yeah, I don't-
beforehand?
I don't
or do
think
you
we
want to
can-
determine the text first and then we can vote on a particular order to issue? My copy of Robert's Rules is not in front of me.
no. Me neither. I don't know what to,
Can I make a suggestion?
Please, Todd.
I'm sorry. You could use the terms that are outlined in the memo and use that as a template or a guide for what will be released in the order itself, or select certain ones, or do a mix and match. That'll
In the
give you
legal
some
minimum?
structure. Yeah, the legal memo. I believe Ms. Brooks has a copy of that. If you all do not have that, certainly, I'm sure she would be willing to read it into the record, or at least read that portion into the record.
And, I mean, now that we're discussing the motion, can I get a sense from the other commissioners of whether they are inclined in this case to include names or not to include names?
informal poll, I am not in favor of including the names.
Same here.
Same here.
I think you know my response, but same here. We've talked, so.
We did. Okay, so then why don't we use Michelle's template, since I think if I were to make a motion to include the names, it would not pass. Why don't we use Michelle's template? In this case, Todd, was there any term in the agreement other than a monetary settlement?
I can go back and check, but the major term was the monetary settlement. So there was no ongoing order or monitoring.
Or
that
or
would-
cease and
no cease and
desist,
desist
some
order,
behavior.
that type of thing.
Okay. So I'm happy to use the template to formulate that order if we can vote on that we ought to issue an order.
Okay. Is there a motion to pass an order?
I believe that's on the floor now.
Oh, it is? Pardon me?
Second.
Do we need to have discussion? Okay, all those in favor of issuing the order, please say aye.
Aye.
Opposed, the same? All right, we are passed.
Okay, and I'm happy, given that, for Todd to formulate the specific language of an order. He said he might need to go back and take a look at the specific language of the agreement to make sure that all of the conditions are in the order. And I don't know how we want to do that. Do we want to leave it to Todd's discretion to come up with that, or would you prefer, Todd, that we hold off on this and formally vote out the order next meeting or something like that?
I don't have a preference, sir.
I'm fine with leaving it to Todd's discretion to issue the order on our behalf, have Daniel sign it at some point during the upcoming weeks, and make sure that all of the terms are fully in there.
Do we all get to see it? I mean,
The order or the
yes,
agreement?
The order. Right?
I think it would have to be distributed to us.
Yeah.
And,
Yeah.
and,
Yeah, I
you
don't
know,
Okay, I just wanted to make sure.
All righty, so we're going to, Todd, is that okay? Leave it to your discretion?
Yes, sir.
We have the information right here, I think.
Yes, sir.
All righty. Ms. Brooks, thank you so much for spending your time, some time with us this evening.
Have a good night.
All right, you too.
Right.
Righty. Todd, do you have an update for us regarding the non-biased police training?
Yes, as a result of Mr. Cruz's comments, we are deciding to push back the training until February. Actually, I'm being a little facetious. There was a scheduling error, or not error, but there was a scheduling difficulty. We were not able to get the presenter for the morning, for the first morning block, because he's got some other commitments and he'd be coming in the middle of the night. So we decided to, rather than have him do what would essentially be 3 weekday sessions and 1 weekend session, we'd really need to get him in for 4 sessions for police department scheduling more than anything else. So the tentative date that we've set is February 16th, 17th, and 18th. Hopefully that's not falling near a holiday. But what we plan on doing, and I'll go ahead and make this announcement at that time, one of the reasons that we have distributed the date and have made this public announcement for whenever we're going to do it, and hopefully we can get it done for the 16th, 17th, and 18th, is that there will be, even though this is a sort of an in-service for our police officers on non-biased police train or non-biased police interaction, we are going to make sure that there are a number of slots available for anyone from the public who wants to participate. Anyone who wants to attend. Now, we're not going to have an unlimited amount of slots because ultimately it is an internal police training. But we're anticipating at least 5 to 7 slots that will be open in each of the 4 weekday sessions for people to attend. Also, for the one on the weekend, we're not exactly sure whether or not there'll be any limitation on how many from the community attend that, because the ones that during the week are specifically geared towards our internal police staff, training them on non-biased policing. The one on the weekend is more intended, I believe, as a forum. So as things begin to materialize and things gel a little bit more, we will have more information available. The one thing I will comment on, though, is, we are looking at this as a sort of first opportunity or initial discussion with key people in the community, people who are particularly interested enough to come spend 4 hours with us and 4 hours in a training to begin to get the type of input that I think has been sort of alluded to earlier. And in terms of trying to find individuals who would be willing to speak with the trainer, we're still at the very, very nascent stages of that. We certainly do think it is something that's important. The presenter thinks it's something that's important. It's just we haven't exactly figured out how. We know that there are certain people that we certainly think should be there, but we're not sure if we're going to be the ones that. That's why I haven't made any phone calls. We're not sure that exactly how we would go about making that determination of who he ends up talking to, because we want him to talk to a good representative sample. We want him to talk to people who are absolutely frustrated with the police department, but we also want him to talk to people who believe that the police department provides good services to their neighborhood. We want there to be a good representation, and at least at this point, that hasn't crystallized exactly how we will do it. And once it does, I'm sure that people will have input into that also. I will tell you that we're just going to try to do it as best as we can in terms of making those types of discretionary judgments.
Great, thank you. Those dates were tentatively February 16th, 17th, and 18th.
Correct.
Awesome, thank you, Todd.
Any questions?
Any questions or comments? All right, let's jump up to head to new business. I think we have a second update on the Phase 2 construction.
Yeah, I just wanted to let the commission know that we are approaching the phase, and Peter, you know a lot more about this than I do. I just wanted to provide it from my perspective, and I'm sure you can better inform them, but we're quickly approaching the phase of the UC2B project where you will take the line or the cable, or I shouldn't use the word cable, but the whatever term Peter uses subsequently, from the hubs, which would be sort of approximately somewhere near the streets, and there would be a certain amount of houses per hub, to the actual doorstep. And so in that phase, we're anticipating that there are going to be, and we are hopeful that there are going to be more opportunities for maybe smaller players to come in and play a part in that. We're not exactly sure how that's going to be. We're talking about how the different contracting could be structured, but I wanted to at least give you an idea that discussions about that phase have begun. My office is involved in those. I'm sure Peter is involved with those discussions at a certain level. So I wanted to provide that to you. As soon as more details sort of crystallize on how it will move forward, I will make sure to keep you informed.
So, Todd, I actually had a question for you on this because it came up at the last UCDB meeting, and I ought to have sent you email ahead of time. I apologize for not doing so. One of the questions that came up was, although the bidding process took place under the university procedures, which is what we as a commission agreed to before that all started for the phase 1, and will continue with the phase 2 bidding process as far as I understand. The question came up as to the monitoring that could be done for whether folks were using the appropriate workforce that they promised or using the appropriate subcontractors. I had said at the UCDB meeting that I had thought that we had passed that all off to the university and their map fee process, but according to the folks at Champaign, they are proceeding with their monitoring process the way they normally do for construction contractors, because the contract itself is under the city of Champaign, and they expected that Urbana would be doing the same. I wanted to check with you and find out, even though the bidding is going this different process than we normally do, are we doing that kind of monitoring, and is the commission involved in that in any way, and what is the appropriate thing going forward?
So this is about phase 1, correct?
Correct.
All right. I need to check with that. No, we are not currently doing that monitoring because we believe that the EEO requirements were fulfilled because the contractors were pre-qualified and because we saw the proof of the contracting, the subcontractors being awarded, or subcontracting being awarded to that certain amount of female and minority-owned contractors. In terms of ongoing monitoring at the site, I will tell you...
And monitoring of the contract ongoing, I don't know how exactly Champaign is undertaking that.
Yeah, I'm not exactly sure either. I will tell you that it's my impression in talking with sort of the people who are involved that there's regular assessment of payroll to ensure that they are sort of doing the types of divisions that were outlined, that, you know, the however many, 15% or whatever that was required minority and female participation. I believe that that's ongoing with the payroll monitoring. I'm not exactly sure, you know, if they're going out to the site. We are not going out to the sites and counting heads in this instance.
Then,
so I can certainly check on that, and I'll get back to you on it.
Great. And other than that, I mean, I think Todd laid it out exactly right. We've got phase 1 going. That construction is underway. That's for the main trunk lines, what are called the rings. And then we've also gotten some hiring underway, I believe, or at least we've taken applications for the folks who will go out door to door, try and distribute information and figure out which particular houses the fiber to the curb, to the premises is going to be. Right now it's at the curb and it's got to get to the premises. And then the phase 2 construction is going from the curb to the premises with the fiber. Once we know which houses and which community anchor organizations are going to be involved in that. So yes, that's going forward now, and looking like we are, at least by the skin of our teeth, meeting schedules. So.
All right, thank you. Tom, moving on to staff report. Where would you like us to begin?
Let's go ahead and start with the approval of the EEO workforce statistics. I need to make a couple of changes. Again, I need to recheck this spreadsheet because it's not totaling in the minority column. If you look at Kinney contractors, it reads there that under the 2011 numbers that when you look at the total minority population, it doesn't show that there are any. When there are really 4, and that amounts to about 8% of their total population. So they've gone from 5.6% minority population to 8% minority population. And then also in GM, these must have been taken from the same format, because in GM Sipes, their population has gone from 1 minority with 7 overall workforce to, I need to count this up again, I think it's 4 minorities in a total workforce of 20, which gives them 25% total. So they've gone from 14.3% of their workforce to 25% of their workforce minority. So I apologize for those errors, and I'll fix the spreadsheet. And so, but I've made you can see the recommendations. If you have any questions about those, I'd be happy to address them.
So we got 3 renewals and 1 new company. Is there a motion on the floor?
Well, I'll go ahead and make the motion for the renewals. I did have a question about unless you want to do questions first, whichever way you want to do it.
Let's get to this.
Let's do the renewals first.
Let's do the renewals.
Okay. I think the renewals are straightforward. So I move that we accept staff recommendations for 2 years for BC Bank, 2 years for Kinney Contractors, and 2 years for GM Sipes Construction.
Is there a second?
Second.
Discussion.
So the only question I had on this, Todd, was Busey. They seem to have been making progress. Their numbers are still bad, but they seem to have done something. Is that what you're basing the 2-year pre-certification on?
Yes, they've had a decrease in their net population, and that in turn they've had an increase in their minority population. That says that their rate of hiring minorities has been very relatively, I should say, relatively positive or good.
I'd like to comment about the GM Sipes, which is not very good as far as hiring females is concerned. And they just don't have a very good percentage there. I know it's construction, but I'm kind of wondering if they're making a real effort.
Other comments or questions? Alrighty, all those in favor of the motion of 2 years for Busey, Kinney, and GM Sipes, please say aye.
Aye.
Opposed, the same? All right. Now we also have a new company,
Logicalis?
Logicalis. It looks like some kind of pharmaceutical. Sorry, Logicalis. We've got a staff recommendation for 2 years.
So, I've got a question here.
Peter, question.
We're buying a bunch of computers from these guys, says the form. So this sounds like a one-shot deal for a company that has pretty darn poor minority representation, as far as I can tell. Is that? I mean, the overall minority representation is including the women, which is 34%, which is not good, but it's not horrible compared to some other companies we see. But African American, Latino, and Asian populations are quite low. And I'm wondering why we're doing 2 years when this sounds like a one-shot deal, and I'm not convinced that this is a great company to be dealing with.
Well, I think, and I could run these numbers again. It looks like when you total the minority categories together, it hits 11.9%. The overall, our sort of North Star is right around 14.7 right now. And basically anyone who has been at least generally between 11 up, we have given 2-year certifications to.
Are we including women in that minority population?
No, we're not.
So the 11.9 is
Just minorities.
Just minority. Do you hear that, Pete?
I can look. I can
Yeah.
look. I can refactor the numbers again, but just-
2.3 plus 4.6 is
I'm just.
7. Yeah, okay. Yep, no, you got it. No, it's the Asian population. I didn't notice
And
how
the
large
Latino
that was.
population.
Yeah.
You did.
Respectable number. Any other comments or questions, or is there a motion for Logicalis on the floor?
I move that we accept the staff recommendation for Logicalis.
Second.
Alrighty, discussion? We done? Alrighty, all those in favor of the 2-year for Logicalis, please say aye.
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 Opposed, the same? Awesome, thank you. Todd?
Okay, looking at the monthly complaint activity report for substantial contacts, you see that since the last time we met, we have 3. Actually, there's one I could add to that that we just had. That complainant was referred on to the Illinois Department of Human Rights, where there was a pending case. So, I wanted to provide that. And then looking at the cases, the first one should be amended to show that at the time that I wrote this report, we were reviewing the settlement agreement. It's now been signed by the complainant. We're awaiting signature from the respondent. In the next 2, we have ongoing settlement negotiations. I fully expect those to be settled by the next time. Of course, I said that the last time, but I expect those to be settled by the next time we speak. The UC 110603, it says fact-finding requests sent. Actually, we've received, that's been sent. We've received the fact-finding back now, and we're currently scheduling fact-finding interviews. And in the next 2, the complaint has been filed, and we're awaiting the initial response.
Great, Todd. Any questions? Anyone?
And then we have a budget report here. I don't think there have been any significant changes since the last time.
No changes in the budget
No.
report?
Right.
Awesome. Anything else?
No, sir, not at this time.
Any announcements?
Yeah,
Pete, we hate you. Are you in San Diego?
sorry,
'Cause it's
No,
cold,
I'm
it's cold
actually
here.
in Shanghai.
What's that?
Shanghai.
I'm in
Oh,
Shanghai.
I did-
It's
okay.
9 o'clock in the morning here.
Well, then I wish you well. What is it like?
Thank you.
What is it?
7 o'clock in the morning.
7 o'clock in the
9
morning?
now.
Wow. Well, that's kind of cool. All right. I thought you were in San Diego, Pete, because it got really cold here today, so
Or 9.
you're not missing anything.
It's raining here in Shanghai.
Well, cool. Have a great trip. Be well, travel safe, and we'll see you guys next month.
Thank
Meeting
you.
adjourned.